After DHS Secretary-designee Andrea Palm claimed to have the power to extend Safer at Home indefinitely, the Wisconsin legislature had had enough. It filed a lawsuit directly with the state Supreme Court, essentially asking it to invalidate the entire Safer at Home order.
Yes, Your Honor. The Emergency Order 28 in its entirety violates Chapter 227 because it is an unpromulgated emergency rule.
The Evers team did not hold back.
Because people will die if this order is enjoined with nothing to replace it. That is exactly what will happen.
The administration says the DHS secretary has practically unlimited power to respond to a public health emergency because the legislature gave her that power under state law.
And the statutory text empowers DHS to take all necessary action to combat communicable diseases. I understand Your Honor may be uncomfortable with that broad grant of authority in the sense that you think it may allow DHS to go too far.
So I think there is a constitutional problem with the legislature giving away this much power to an unelected cabinet secretary. The people never consented to a single individual having that kind of power.
Justice Dan Kelly said Palm has assumed the power to single-handedly write state criminal law that is currently sending people to jail.
Your position is the secretary can identify behavior that is not otherwise criminal, and she can, all by herself, sit down at her computer keyboard, write up a description of behavior, and make it criminal, correct?
What I would say, Your Honor, is the legislature has created this statutory scheme itself.
So before you get to the justification, could you answer my question? She could do that, correct? She can sit down at her keyboard all by herself.
Yes, the scope of available enforcement is determined by the order, yes.
Justice Rebecca Bradley says the state constitution does not give any one person that kind of power.
Where in the Constitution did the people of Wisconsin confer authority on a single unelected cabinet secretary to compel almost 6 million people to stay at home and close their businesses and face imprisonment if they don't comply, with no input from the legislature, without the consent of the people? Isn't it the very definition of tyranny for one person to order people to be imprisoned for going to work, among other ordinarily lawful activities? Where does the Constitution say that's permissible, counsel?
The administration's counsel said if the court does not like it, then it should ask the legislature to change the law.
The Constitution provides that the legislature may enact statutes to protect the public health, and that is exactly what the legislature has done in Chapter 252.02, sub 3, 4, and 6. So I think that expression of legislative intent that grants DHS the power to do whatever is necessary to combat a novel, deadly, communicable disease like the one we're facing today is where we find that consent.
Under your interpretation of the statutes, she can do whatever she wants, and she can order people to jail if they don't comply. And I don't think the legislature can give that kind of power to an unelected individual.
The Supreme Court deliberated Tuesday afternoon. If it rules in favor of the legislature, Palm will have to submit her proposals to it for approval through the administrative rules-making process. If it rules for Palm, she'll get to continue to rule without oversight until she says it's safe to reopen Wisconsin, which could be months or even years. For the MacIver Institute, I'm Bill Osmolsky.